Will or estate plan, find out what you need. Having an up-to-date will is critical, but this important document is just one of the components in creating an estate plan. People often believe that writing a will is the only thing needed to transition wealth from one generation to the next. However, modern-day family arrangements, compulsory superannuation, complicated business structures, our ageing population, and the aged care system have all meant the legalities that follow a death have become more complex. Estate planning has become important to everyday Australians, not just the wealthy elite. Even if we don't feel rich, skyrocketing house prices, large superannuation balances, and generous insurance benefits have meant that many of us have substantial wealth to pass on. This is where it becomes important to plan how the transmission of your wealth will take place. In order to have your wishes carried out as intended, it is necessary to understand which estate planning documents are required to cover your individual circumstances. A will, a testamentary trust, a death benefit nomination form, or other documents may be necessary. It starts by understanding that a will only extends to transmission of assets in your deceased estate. Also, there are some key questions a complete estate plan might address. These include: who has the power to manage your finances and distribute your assets after you are gone? Who decides where your superannuation benefits will be paid, and will this be done in a way to minimise tax? How do you ensure your wealth is transmitted to intended recipients in a way that minimises taxes? Taxes on money you have already been taxed on while you're alive. Who will be your decision maker in the event of incapacity, and should that person's decision-making power be limited? Who will advocate your wishes regarding medical treatments or resuscitation if you are ever seriously ill and unable to communicate? How will you arrange your assets while you're alive to ensure you effectively exclude an estranged person that would ordinarily be a beneficiary? Can this be done to lessen the subsequent emotional and financial cost of estate litigation? How will you ensure control of your existing family trust is managed so one person does not exploit a position of power and take more than you intended? How will you make sure a beneficiary's inheritance is not lost or depleted should they subsequently separate from their partner? How will you protect the nest egg you have provided to vulnerable or disabled beneficiaries? How will you help your beneficiaries retain their inherited assets if they have a judgment awarded against them or they become bankrupt? These are often issues that require more than preparing a simple will. These are the types of issues addressed in a more comprehensive estate plan. The only things a will addresses are the assets in your deceased estate to ensure they are transferred to beneficiaries that you nominate. Now here's the catch. From a legal perspective, not all assets that you own or control will necessarily fall within your deceased estate. If you have a valid will, you may think everything is covered, but often some very significant property under your control may not constitute an asset of your deceased estate. Estate and non-estate assets need to be identified and considered separately to ensure your wishes are carried out. A number of factors may determine whether an asset is an estate or non-estate asset. This may differ from person to person, depending upon how things have been set up. So, here is a general guide. Property that is excluded from your deceased estate can include assets, such as your home that you own jointly with another person. A superannuation death benefit paid to a nominated dependent. Assets held within a family trust. Life insurance where the deceased is not the policy owner. And assets held by a company, depending on how the shareholding is structured. So, in trying to decide if you need a simple will or should consider a more comprehensive estate plan, you need to reflect upon these types of questions. If, at the very least, you have a home, superannuation or a life insurance policy, you should not necessarily rely on a will alone. Consider an estate plan. Simple and decisive steps taken today can ensure the fruits of your labour are dispersed in the way you intend. You can leave a meaningful legacy to be remembered by, not a poorly conceived document leaving many unanswered questions to cause confusion, stress, and possible litigation. Are you ready to take the next steps? The first step towards an estate plan is making contact with us for a free blueprint session. It will cost you nothing apart from 20 minutes of your time. In the free blueprint session, we map out your next best steps moving forward. Why free? The reason we provide the blueprint session for free is so you can determine if Liberty Law is a good fit for you, and so we can determine if you are a good fit for the services and expertise we offer. Regardless of the outcome, the blueprint is yours to keep. To find out more and book your blueprint, visit www.libertylaw.com.au/free blueprint or call us on 07 3216 1999. Liberty Law is a firm of registered Australian legal practitioners focused on quality wills and estate plans. Estate planning can be complex, but at Liberty Law, our fixed fee services represent excellent value for money, and our plain-speaking, down-to-earth lawyers ensure your estate plan is prepared with professionalism, discretion, and minimum fuss. Once you have planned your estate, you can rest easy, knowing that you've done all you can to make things easy for those left behind. Book your free 20-minute Liberty Law Blueprint session with us today.